Welcome to this exam review from Birdsy, your AI-powered study partner. Be sure to like and subscribe for more videos, and don't miss what's happening in the lower corner of the screen. It could be just the thing you need to pass your exam. Let's get started.
Let's start with a look at water rights, riparian, and littoral doctrines. Riparian rights, littoral rights, and doctrine of prior appropriation. What is the primary difference between riparian rights and littoral rights? Is it A, riparian rights apply to stationary water, littoral to flowing water? B, riparian rights apply to flowing water, littoral to stationary water? C, both apply only to groundwater? Or D, both are used interchangeably? The answer is B, riparian rights apply to flowing water, littoral to stationary water. Riparian rights pertain to landowners whose property is adjacent to flowing water, like rivers, while littoral rights apply to landowners whose property borders stationary water, such as lakes or seas. Under the doctrine of prior appropriation, what determines water rights? Is it A, proximity to the water source? B, size of the land owned? C, first beneficial use of the water? Or D, government allocation? The answer is C, first beneficial use of the water. The doctrine of prior appropriation grants water rights based on the principle of first in time, first in right, meaning the first person to use the water for a beneficial purpose has the right to continue using it.
Have you noticed the code in the bottom corner? Next time you're stumped, take that code to birdsy.ai for immediate help and a free study session with Birdsy, your personal AI study partner. Plus, you'll get access to hundreds of additional questions, helping you move closer to passing your exam with confidence. The next time you're feeling unsure or stuck, give it a try.
A farmer in a western state diverts water from a river for irrigation. What doctrine governs his water rights? Is it A, riparian rights? B, littoral rights? C, common law rights? Or D, doctrine of prior appropriation? The answer is D, doctrine of prior appropriation. In Western states, water rights are typically governed by the doctrine of prior appropriation, which prioritizes water rights based on the first beneficial use. Which of the following is not a characteristic of riparian rights? Is it A, allow unrestricted diversion of water? B, apply to land adjacent to flowing water? C, include reasonable use of water? Or D, shared among all riparian landowners? The answer is A, allow unrestricted diversion of water. Why this question may seem a bit tricky, riparian rights are often confused with other water rights. They do not allow for water diversion that harms downstream users, which is a common misconception. Accretion, reliction, avulsion, and erosion effects on property lines. What is the primary difference between riparian and littoral rights? Is it A, riparian rights are for oceanfront properties? B, riparian rights are for properties next to rivers, while littoral rights are for lakes? C, littoral rights apply to properties next to any water body? Or D, both rights apply to properties next to any water body? The answer is B, riparian rights are for properties next to rivers, while littoral rights are for lakes. Riparian rights pertain to properties adjacent to flowing water like rivers, while littoral rights relate to properties next to static water bodies like lakes. A property owner notices that their land has increased due to gradual sediment deposit from a nearby river. What legal concept does this situation illustrate? Is it A, avulsion? B, C, accretion? Or D, reliction? The answer is C, accretion. Accretion is the gradual increase of land by natural forces, such as sediment deposit from a river. How does avulsion affect property lines compared to accretion? Is it A, both change property lines gradually? B, both do not affect property lines? C, avulsion changes property lines, accretion does not? Or D, avulsion does not change property lines, accretion does? The answer is D. Avulsion does not change property lines, accretion does. Why this question may seem a bit tricky. Avulsion does not change property lines because it involves sudden changes, whereas accretion can alter property lines gradually. Escheat and involuntary alienation. Escheat, when property reverts to state and no heirs. What happens to a property when the owner dies without a will and no heirs can be found? Is it A, the property escheats to the state? B, the property is auctioned off? C, the property is donated to charity? Or D, the property remains unclaimed indefinitely? The answer is A, the property escheats to the state. When a property owner dies without a will and no heirs, the property escheats to the state, meaning it reverts to state ownership. A property owner dies intestate with no known relatives. What legal process allows the state to claim the property? Is it A, adverse possession? B, escheat? C, eminent domain? Or D, foreclosure? The answer is B, escheat. Escheat is the legal process that allows the state to claim ownership of a property when the owner dies without a will and no heirs. If a property owner dies without a will and has distant relatives, can the property still escheat to the state? Is it A, yes, immediately? B, yes, after a year? C, no, distant relatives always prevent escheat? Or D, yes, if no legal heirs are recognized? The answer is D, yes, if no legal heirs are recognized. Why this question may seem a bit tricky. Distant relatives can prevent escheat if they are legally recognized as heirs, but if no legal heirs are found, escheat can occur.
Finding this exam review helpful? If you haven't already, like and subscribe for more videos that'll get you ready to pass.
Involuntary alienation methods: adverse possession, eminent domain, foreclosure, forfeiture. What is the legal process called when the government takes private property for public use with compensation to the owner? Is it A, eminent domain? B, adverse possession? C, foreclosure? Or D, forfeiture? The answer is A, eminent domain. Eminent domain is the process where the government can take private property for public use, provided they offer just compensation to the owner. Which method of involuntary alienation involves losing property due to failure to meet legal obligations, such as paying taxes? Is it A, adverse possession? B, eminent domain? C, foreclosure? Or D, forfeiture? The answer is D, forfeiture. Forfeiture occurs when property is lost due to failure to meet legal obligations, such as not paying taxes or violating laws. A homeowner has not paid their mortgage for several months. What process might the lender initiate to recover the owed money? Is it A, adverse possession? B, eminent domain? C, foreclosure? Or D, forfeiture? The answer is C, foreclosure. Foreclosure is the legal process initiated by a lender to recover the balance of a loan from a borrower who has stopped making payments. Which method of involuntary alienation allows someone to acquire ownership of property by openly occupying it for a statutory period? Is it A, eminent domain? B, adverse possession? C, foreclosure? Or D, Forfeiture. The answer is B, adverse possession. Why this question may seem a bit tricky. Adverse possession requires open, notorious, and continuous occupation, which can be confused with other legal terms. Subdivision, condominium, and airspace rules. Subdivision/plat map rules and public reports, lot line quirks. What is the primary purpose of a plat map in a subdivision? Is it A, to determine property taxes, B, to illustrate the layout of a subdivision, C, to establish building codes, or D, to calculate water usage? The answer is B, to illustrate the layout of a subdivision. A plat map is primarily used to show the layout of a subdivision, including lot boundaries, streets, and easements. It is essential for understanding the division of land and ensuring compliance with zoning laws. When reviewing a plat map for a new subdivision, what might be overlooked that could affect future property boundaries? Is it A, the scale of the map, B, the zoning classification, C, easements and rights-of-way, or D, the developer's contact information? The answer is C, easements and rights-of-way. Why this question may seem a bit tricky. Plat maps often include easements and rights-of-way that are not immediately obvious, but can significantly impact property boundaries and usage rights. In a subdivision, which document is most likely to reveal quirks in lot lines that could affect property boundaries? Is it A, zoning ordinance, B, public report, C, survey, or D, building permit? The answer is C, survey. Why this question may seem a bit tricky. A plat map shows the intended layout, but a survey provides precise measurements that can reveal discrepancies between intended and actual lot lines. Condominium airspace ownership, common elements, cooperative versus condo pitfalls. What is a common element in a condominium? Is it A, hallways, B, private balconies, C, individual unit interiors, or D, personal parking spaces? The answer is A, hallways. Common elements are parts of a condominium property that are shared by all unit owners, such as hallways, elevators, and recreational facilities. A buyer is considering purchasing a unit in a cooperative. What is a potential pitfall they should be aware of compared to a condominium? Is it A, higher property taxes, B, difficulty in obtaining financing, C, lack of common areas, or D, no board approval required? The answer is B, difficulty in obtaining financing. In a cooperative, buyers purchase shares in the corporation, not the real estate itself, which can complicate financing and resale. In a condominium, who typically owns the airspace within a unit? Is it A, the condominium association, B, the local government, C, the unit owner, or D, the building developer? The answer is C, the unit owner. Why this question may seem a bit tricky. Airspace ownership can be confusing. In a condo, the unit owner owns the airspace within their unit, while the building structure is part of the common elements. Environmental, disclosure, and hazardous property rules. Mandatory environmental disclosures and known hazards: lead, mold, asbestos, underground tanks. What is the primary purpose of mandatory environmental disclosures in real estate transactions? Is it A, to increase property value, B, to inform buyers of potential environmental hazards, C, to comply with zoning laws, or D, to reduce property taxes? The answer is B, to inform buyers of potential environmental hazards. Mandatory environmental disclosures ensure that buyers are informed about potential environmental hazards such as lead or asbestos, which could affect their health and the property's value. Which hazardous material must be disclosed if found in a home built before 1978? Is it A, lead-based paint, B, radon gas, C, carbon monoxide, or D, asbestos? The answer is A, lead-based paint. Lead-based paint must be disclosed in homes built before 1978 due to its potential health risks, especially to children. What is a common requirement for sellers regarding underground storage tanks? Is it A, remove them before selling, B, ignore them if not leaking, C, disclose their presence, or D, test them for leaks? The answer is C, disclose their presence. Sellers are typically required to disclose the presence of underground storage tanks due to potential environmental hazards such as leaks. A buyer discovers mold in the basement after purchasing a home. What should have been done during the transaction process? Is it A, the buyer should have conducted a mold test, B, the seller should have disclosed the mold issue, C, the buyer should have waived the inspection, or D, the seller should have removed the mold? The answer is B, the seller should have disclosed the mold issue. Sellers are required to disclose known mold issues to potential buyers to prevent post-purchase surprises and potential health risks. Which of the following is not typically required to be disclosed in a real estate transaction? Is it A, presence of asbestos, B, lead-based paint, C, underground storage tanks, or D, neighborhood crime rates? The answer is D, neighborhood crime rates. Why this question may seem a bit tricky, it tests knowledge of what is typically disclosed. While environmental hazards like lead and asbestos must be disclosed, general neighborhood crime rates are not a mandatory disclosure.
Finding this helpful? Hit like and subscribe so you'll be the first to see new exam prep videos on the topics you need to master, all with Birdsy, your AI-powered study partner.
Clean title exceptions for contaminated land, disclosure obligations, as-is clauses. What is a clean title exception for contaminated land? Is it A, a title with no liens or encumbrances, B, a title that may have environmental liens due to contamination, C, a title that guarantees no contamination, or D, a title that includes all property rights? The answer is B, a title that may have environmental liens due to contamination. A clean title exception for contaminated land means that the title may not be free of environmental liens or obligations due to contamination issues. What is the primary purpose of disclosure obligations in real estate transactions? Is it A, to inform buyers of known property defects, B, to guarantee the property is free of defects, C, to provide a warranty for the property, or D, to ensure the property is sold as is? The answer is A, to inform buyers of known property defects. Disclosure obligations ensure that buyers are informed of any known defects or issues with the property, including environmental hazards. A buyer discovers a hazardous waste site near the property after purchase. The seller did not disclose this. What is the likely outcome? Is it A, the buyer must accept the property as is, B, the buyer can demand a price reduction, C, the seller may face legal action for non-disclosure, or D, the transaction is automatically void? The answer is C, the seller may face legal action for non-disclosure. The seller may be liable for failing to disclose known environmental hazards, potentially leading to legal action or rescission of the sale. How does an as-is clause affect a buyer's rights regarding undisclosed property defects? Is it A, it removes all buyer protections, B, it guarantees the property is defect-free, C, it requires the seller to fix all defects, or D, It limits the seller's liability but requires disclosure of known issues. The answer is D. It limits the seller's liability but requires disclosure of known issues. Why this question may seem a bit tricky. An as-is clause limits the seller's liability for defects, but it does not absolve them from disclosing known issues. Other quirk rules and edge case pitfalls. Doctrine of prior appropriation versus riparian in water-scarce states. What is the primary difference between the doctrine of prior appropriation and riparian rights in water-scarce states? Is it A? Prior appropriation is based on first use, riparian on land adjacency. B. Riparian rights are based on first use, prior appropriation on land adjacency. C. Both doctrines prioritize land ownership over water use. Or D. Both doctrines prioritize first use over land ownership. The answer is A. Prior appropriation is based on first use, riparian on land adjacency. Prior appropriation grants water rights based on a first-come, first-served basis, while riparian rights are based on land ownership adjacent to water bodies. In a water-scarce state, which doctrine allows a landowner to use water from a river flowing through their property? Is it A. Doctrine of prior appropriation, B. Doctrine of equitable distribution, C. Riparian rights, or D. Doctrine of absolute ownership? The answer is C. Riparian rights. Riparian rights allow landowners to use water from a river that flows through or adjacent to their property. A farmer in a water-scarce state wants to divert water from a nearby river for irrigation. The river is not adjacent to his land. Which doctrine applies? Is it A. Riparian rights, B. Doctrine of prior appropriation, C. Doctrine of reasonable use, or D. Doctrine of natural flow? The answer is B. Doctrine of prior appropriation. In water-scarce states, the doctrine of prior appropriation applies, allowing water use based on first appropriation rather than land adjacency. In a water-scarce state, can a landowner with riparian rights prevent upstream users from diverting water under prior appropriation? Is it A. Yes, riparian rights always take precedence. B. Yes, if the landowner was the first to use the water. C. No, riparian rights are irrelevant in these states. Or D. No, prior appropriation rights take precedence. The answer is D. No, prior appropriation rights take precedence. Why this question may seem a bit tricky. Riparian rights do not override prior appropriation in water-scarce states, where first use is prioritized over land adjacency. Rules about mineral/subsurface rights, air rights, and implied easements. What is typically included in mineral rights when purchasing a property? Is it A. The right to extract minerals beneath the surface, B. The right to build structures on the surface, C. The right to use airspace above the property, or D. The right to access water resources on the property? The answer is A. The right to extract minerals beneath the surface. Mineral rights often include the right to extract minerals beneath the surface, such as oil, gas, and coal. These rights can be sold or leased separately from the land. A property owner discovers oil beneath their land. However, the mineral rights were sold to another party years ago. Who has the right to extract the oil? Is it A. The current property owner, B. The local government, C. The holder of the mineral rights, or D. The previous property owner? The answer is C. The holder of the mineral rights. The party holding the mineral rights has the legal authority to extract minerals, including oil, from beneath the land. What is an implied easement? Is it A. A written agreement granting property access. B. A right inferred from the use or necessity of the property. C. A temporary permission to use property. Or D. A government-granted right to use land. The answer is B. A right inferred from the use or necessity of the property. An implied easement is a right to use another's property that is not explicitly stated but is inferred from the circumstances or actions of the parties. Traps and trick questions. Does title TAS? Severance versus fixture in weird cases. No heirs versus intestacy. In the context of real estate, what determines whether an item is considered a fixture or personal property? Is it A, the item's age? B, the method of attachment? C, the item's color? Or D, the item's size? The answer is B, the method of attachment. Fixtures are items that are permanently attached to the property, while personal property can be removed without causing damage. What happens to a property if the owner dies without heirs or a will? Is it A, it is auctioned off? B, it is given to the nearest relative? C, it escheats to the state? Or D, it remains unclaimed indefinitely? The answer is C, it escheats to the state. When there are no heirs or a will, the property typically escheats to the state. What is the legal term for the transfer of property ownership upon the owner's death without a will? Is it A, intestacy? B, escheat? C, probate? Or D, severance? The answer is A, intestacy. Intestacy is the legal process that governs the distribution of an estate when there is no will. A homeowner installs a custom bookshelf that is bolted to the wall. When selling the house, can the bookshelf be removed? Is it A, yes, because it is personal property? B, yes, because it is not permanently attached? C, no, because it is a personal item? Or D, no, because it is a fixture? The answer is D, no, because it is a fixture. Fixtures, like a bolted bookshelf, are considered part of the property and typically cannot be removed without agreement.
Thanks for watching. If you found this exam review helpful, be sure to subscribe for more real-world practice and topic-focused study videos. And visit birdsy.ai to start your free trial of Birdsy, your AI-powered study partner.